Good morning, colleagues. Let's welcome all of you today, Tuesday, 2nd August 2022. I want to welcome all of you honorable members of this committee here at M46 and all of those in virtual platform. I want to acknowledge and welcome the Public Protector, as well as the legal team of the Public Protector. I'm aware today, as indicated yesterday, that team will be led by Advocate Chabalala. And I want to also acknowledge and welcome the evidence leaders, Advocate Bauer and Advocate Mayosi. Welcome members of the media joining us, the entire support staff of this committee. Last but always special, to welcome and thank members of the public who have started this inquiry with us, are with us every day. As South Africans watching this in your various platforms, 408, YouTube, you're welcome. Feel as if you are in this room as well. Thank you, colleagues. I'm not referring to the witness yet because I will be led by Advocate Bauer there before the witness is introduced. Advocate Bauer, as she is busy, just to indicate the following before she takes the platform. The timelines for today will be as follows. Evidence leaders are going to lead evidence from 10 up to 12. And from 12 up to 3, it's going to be the team of the Public Protector. Thereafter, members are going to interact. Those are today's timelines. I repeat, the evidence leaders will start from 10 to 12. And from 12 to 3, it is going to be the team of the Public Protector. Thereafter, members are going to interact with the witness. Those are our today's timelines. I now want to recognize Advocate Bauer.
Good morning. We're calling the witness today is Mr. Vusi Sunnyboy Mahlangu.
Thank you. Vusi Mahlangu, but I now go to recognize Mr. Jenkins, who's standing in place of Ms. Fatima Ibrahim to do the important part of introducing the witness to this inquiry. Mr. Jenkins, can you hear us?
I can hear you, Honourable Chairperson. Good morning. Good morning. For the other honourable members, Public Protector and her team, Advocate Pofu, and my colleagues and all other members there. Good morning. I can hear you, Chairperson. Should I continue?
Yes, today the Public Protector team is led by Advocate Chabalala. But you now can proceed.
Yes, good morning, Advocate Chabalala. Thank you, Chairperson. I want to greet the witness, Mr. Mahlangu. Good morning, Mr. Mahlangu.
Good morning.
Good morning, sir. For the record, could you please state your full name?
And you can keep your mic on, Mr. Mahlangu.
Thanks, Chair. I'm Vusi Sunnyboy Mahlangu.
Thank you, Mr. Mahlangu. Mr. Mahlangu, I've been asked to administer the oath before you commence with your testimony. So I'd just like to read it to you, and at the end I will ask you to either, with an oath or affirmation, I don't know which you prefer, an oath or affirmation just to seal the deal, if I can call it that.
Any.
Okay, fine. So, Mr. Mhlanga, you've been invited, subject to the provisions of Section 60 of the Powers, Privilege and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector Advocate Makwebane. So, Mr. Mhlanga, please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. It's very important to note the following, please. You are, however, protected in that the evidence given under oath or affirmation before this committee or before the House may not be used against you in any court or place outside Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Do you understand that, Mr. Mhlanga?
Yes.
Thank you. So please be aware of the following as well. In terms of Section 17, subsection 2 of the Powers, Privilege and Immunities of Parliament and Provincial Legislatures Act, a person who willfully furnishes the House or a committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment or for a period not exceeding 2 years. Do you understand that, Mr. Mhlanga?
Yes.
Thank you. So now you are required to take the oath or affirm that the evidence you're about to give is truthful. You did not indicate any preference, so if you do not mind, and please indicate if you do mind, I will use the oath. So I'm going to read it to you and just affirm it afterwards, please, that you agree. So, Mr. Mhlanga, you swear that the evidence that you will give shall be the truth, the whole truth, and nothing but the truth, so help me God. Please raise your hand and affirm that, please.
Yes.
Thank you very much. So the oath has been administered, Chairperson. Thank you very much.
Good morning, Mr. Mhlanga. You prepared an affidavit, you deposed to an affidavit, and you were assisted by the evidence leaders in the preparation of that affidavit.
Yes.
Can you explain the interaction that you had with the evidence leaders leading up to this inquiry? And I'm specifically dealing it with reference to paragraph 3 of your affidavit so that you can follow as I ask the questions.
Okay, thanks. Chair, as stated in my affidavit, paragraph 3, I was contacted by the 2 evidence leaders, and then they informed me of this committee and what it's doing. And they provided me with the information, like stated here, more than 10,000 pages. I sift through the documentation. Obviously, I focus on some that are more relevant to what I've been doing when I was still at the Public Protector South Africa. And then we started compiling the affidavit, and they assisted me thereof.
Mr. Mhlanga, at the time you were informed that your name had come up and you were specifically mentioned in relation to charge 4, and for that reason it was important that we were able to meet with you in order that you could put your version before the committee. Would that accord with your recollection?
Yes, like I said, there was a lot of information, but I decided to focus mainly where my name is being mentioned so that I can clarify the misconceptions that prevail there and also the misrepresentations that I pick up in those documents. Hence, I wrote my own version, the affidavit.
And in fact, when you met with us, you made it quite clear that you had not had an opportunity to read the entire 10,000 pages plus, correct?
Yeah, it was so difficult that one can go through the entire documentation. That is why I was very selective in my reading.
And in paragraph 4 you explain your motivation in being prepared to make the affidavit. Correct?
Yes.
And can you just tell the committee what that was?
It's basically that there was so much that was said about me when I was an accounting officer. So it became important that I come and clarify to this committee those issues that were raised about me.
And although you had no desire to want to come and give evidence before parliamentary committee, you provided the affidavit and you indicated that if you were called, you would come to do so, correct?
Yes, I was always flexible. The intention was not to come, but I made it clear to the evidence leaders that if there needs be, I am flexible to come, hence I'm here.
Now, Mr. Mashango, maybe if we took the general proposition and then work into the specifics as that is the format of your affidavit, it would be easier.
Yeah.
You point out in paragraph 5 what your answer is to the allegation that has been made against you. Can you maybe tell the committee what that is?
The main allegation was basically me intimidating the staff, harassing or victimizing them when I was the CEO. So that's the main issue that needs to be clarified.
Just a pause, Advocate Bauer. Honorable Conrad.
Through you, Chair, can I ask Mr. Mashango to speak into his microphone because it's actually tilted
All right.
side.
Just bring it closer to you, almost about close to kissing it, but not kissing it.
Whatever.
Yes, now we can hear you. Thank you.
Okay.
And what is your view in relation to the allegation? What is your position?
Well, maybe as we go along the affidavit, I'll be able to state my case. You see, the intention here is to deal with each and every one of the allegations one by one so that I don't generalize, but I can demonstrate to the committee how things transpired and how things were handled, especially on the disciplinary matters.
Well, I'm going to take you there, but in paragraph 5, you at the outset state that you deny having intimidated, harassed, or victimized any staff members whilst you're in the employ of the CEO. So I just wanted to get the general proposition out of the way before we come to the specifics.
Well, I deny it.
Yeah.
Yes.
And you also made it very clear upfront that prior to your employment at the PPSA, did you know Advocate Mkhubane at all?
Not at all.
Now, in dealing with it, we set out in the affidavit, we first deal with your background. And what I realized last night was not in your affidavit, which would be useful for the committee, is to just give them an idea of your qualifications.
Okay, I'm a graduate of, I have a degree in public administration and an honors in public administration, as well as an honors in political science. I have acquired a number of certificates, lately being the pre-entry SMS program for public service. Yeah.
Okay. You, prior to your employment at the Public Protector's Office, you were the Deputy Director General Land Reform in the Department of Rural Development and Land Reform, correct?
True. Yes.
And you answered initially to 2 ministers. Who were they?
Excuse me?
You answered to 2 ministers during your...
Yes, I reported basically during my tenure, I think it was Minister Kringwana, and then later it became Minister Nkwinti.
Right. And during the course of your employment, you faced disciplinary charges.
Yes.
Correct? And those disciplinary charges is attached to your affidavit at page 2729.
Yes.
Right. Can you just take the committee through those charges? There were 5 charges.
2729, okay, included.
And then 2729.
Yes.
And then maybe just briefly explain the context of the charges.
Yeah, okay.
Sorry, Advocate Bauer. Sorry, Mr. Mahlangu. Just before we proceed, because I just want to make sure I got this right. You said you are reporting to 2 ministers. Were you at a DG or a DGG?
No, I think the question was about during your tenure, who was the ministers there? So the first minister.
No, then I get it. Otherwise,
Yes.
you were not reporting.
No, I was not
Oh,
reporting.
that
It
would
was-
have been the DG
Yes.
doing that.
Yes.
Thank you, Advocate Bauer.
My apologies. I think I phrased the question
Yeah.
clumsily. Sorry.
Proceed.
Yes.
No, okay. 2729 is the attachment that has a VSM1. It talks about the allegations of misconduct and notice to attend disciplinary hearing in terms of Chapter 7 of the Senior Management Service Handbook. Is there, I think, you see a number of charges. The first one is that Mr. Mahlangu is a Deputy Director, General Land Reform, and of being employed by the Department of Rural Development and Land Reform, and therefore an officer of the Public Service of South Africa and a member of the Senior Management SMS are hereby charged with misconduct in terms of Chapter 7 of the SMS Handbook for the acts of misconduct as set out in this charge sheet. You are hereby given notice to attend a disciplinary hearing in terms of clauses 271 of Disciplinary Code Chapter 7 SMS. Then the second one,
Sorry, Mr. Mahlangu, I don't think we need you to read it through.
Oh, okay.
Let me then rather just lead you through the charges.
Okay. No,
Okay?
Yeah.
Effectively, you were charged with 6 charges of misconduct.
Yes.
Well, 6 charges, right?
Yes.
And this related to land that was inquired at the Bekenvlei, known as the PLAS project.
Yes.
And can you just briefly tell us what that was?
Just a brief background, I won't be long. Land reform has got 3 components. You've got the famous redistribution, and then you have the tenure, security, and then you have a restitution, where normally families will claim their ancestral land. The PLAS, which is a proactive land acquisition strategy, was a main program within the redistribution. Why is it PLAS? Because the department took a decision that we shall proactively acquire the land and warehouse it, which means that there doesn't need to have an applicant for that land. But if we come across a land that is for sale, we'll buy it, put it there, identify beneficiaries, and place them later. So this was a main, this Bekenvlei became one of the projects whereby we bought and then we warehoused and later we allocated to beneficiaries.
Right, and the allegations emanated in 2011 relating to the identification, selection, appointment, and approval of the beneficiaries selected for the Bekenvlei PLAS project, correct?
Yes.
And so charges 1, charges 2, charges 3, 4, and 5 related to the issue of the beneficiaries and the acquisition and instructions on the relating to the land, correct?
Yes.
And then charge 6 related to an that you were charged with misconduct in that you unlawfully caused funds budgeted for other projects in the National Office to be allocated to the acquisition of the Bekenvlei PLAS project.
Yes.
Correct?
Mhm.
You were found guilty of charges 1 to 5
Yes.
and not charge 6.
Yes.
And what was the rationale behind the thinking that you were not guilty under charge 6?
The charge 6 basically speaks to the violation of the PFMA. As the Deputy Director General and Reform, I had all the delegations to shift the funds around. For instance, if I can make an example, let's say a particular province is still behind in finalizing the paperwork to acquire the land, and one province is ready. Towards the end of the financial year, we'll take stock to say who's ready, so that we don't do the underspending. Then I will shift funds where I know that the province will be able to acquire. So they find out that that particular charge, it's not applicable because I had those dedications, and this was part of the strategy of avoiding underspending and compromising service delivery.
Okay, and so if you go to 2733, you were dismissed pursuant to these disciplinary proceedings.
Yes.
Correct?
Yeah.
And then, if we go to, so the essence, Mr. Mahlangu, is that you were not found guilty of corruption, or you were not found guilty of any misappropriation of funds.
Yes.
That's the essence of,
Yes.
of not having been found guilty on charge 6 and only on the
Yes.
first 5 charges. All right?
Yes.
You then instituted review proceedings
Yes.
in the Labour Court, correct?
Yes.
And these proceedings were instituted on 12 April 2018.
Yes.
And were they opposed?
Yes, they were opposed.
There was then a spat about whether the review had lapsed and whether the application should be reinstated, correct?
Yes.
There's a judgment which is attached to your papers at 2734,
Yes.
and that's the judgment of the court which reinstates the review application.
Yes.
And the matter is still pending,
Yes.
right? Now, you then applied for the job as CEO at the PPSA in 2018, correct?
Yes.
Right? And you responded to an advertisement to do so.
Yes.
Mr. Mahlangu, I had a copy of that advertisement and I shared it with you last night, and between me and you, I could not find it by the time I got home. So I don't know if I meant to ask you this morning, but it's neither here nor there. Right, if we go to page 2744 of your affidavit.
Yes, thanks, Sunday.
Right, this is, although it's not identified on the document, I've double checked, it's an excerpt of section 61 of the Public Service Regulation in Government Notice Regulation 877 of 2016. And can you explain to us, Mr. Mahlangu, what this reflects?
Okay, Chair, the schedule in 2744, it's basically outlining or is the classification of the acts of misconduct that you will typically find in the public service and what it means to the prohibition of being reappointed in the public service once you have been dismissed. It's your middle box talk about the act of misconduct. For instance, the first one, it will say the offering or recipient of any undue gratification or the facilitation of such offending or receipt of. Then it tells you the period of prohibition before you can be reconsidered in the public service. The first one will be 5 years, and then you've got A, B, C up until D, and then you've got the second one that talks about sexual harassment. Then the B, unfair discrimination, that will give the number of years for prohibition, 4 years, and then you move to the next one, that is 3 years. And then the last one, which is 1 year. So if you go back to the charges, The charges relate to misconduct, not any of the first three, which is a receipt of gratification, committing theft or fraud, conducting business, blah, blah, blah. And then it basically talks about contravention of any provisions of regulations 11 to 14 of chapter 2 of these regulations other than misconduct referred to in terms 1 to 3, which means literally I was prohibited for a year, 12 months before I can rejoin any government institution.
And in essence, by the time you applied for the position at the PPSA, that year had elapsed.
Yes,
Right.
I was now eligible.
So you were appointed at this, you had an interview. Who conducted that interview?
The interview, it was current public protector, the chairperson of the Public Service Commission, the deputy public protector, advocate Kevin Malunga, and the secretariat, I think was the HR head of the public protector South Africa.
Was it the Public Service Commission or the Public Servants Association?
Public Service Commission.
Okay. Right. And you were then appointed for a period of 3 months.
Yes.
Pursuant to an appointment letter. Correct?
Yes.
Right. And okay, after that 3 months, and why was it that you were only appointed for 3 month period?
I think it was their standard way of doing things to say you shall be under probation. I think it was 3 months to 6 months before the public protector makes a decision about full-time employment.
Okay. And if you see page 1452, which may be in the documentation provided to you, but it will be flagged on the screen. 1452.
Where do you find it? 14.
Would be bundle F. Just give me a sec.
Okay, got it.
That will be part of item 60 or 61. 60. So it's 1452.
Yeah.
The next one, 61. Right. Okay. So even though your fixed term contract said 3 months,
Yes.
a performance agreement is concluded between yourself and the public protector for 1 year from 1 May 2018 to 31 March 2019.
The rationale around that was that your performance agreement must always be aligned to a financial year because it's a statutory requirement in terms of the DPSA. So whether there will be an extension or not, but at least the performance agreement to talk to the financial year.
Okay. And then after the period of 3 months, your position was then extended, correct?
Yes.
And if you go to 1458,
Yes. And then, got it.
the extension was then from 1 August 2018 to 31 July 2019.
Yes.
correct?
Mhm.
And if we just look at that for a moment,
Okay.
we'll flag it and we'll come back to it,
Mhm.
is the condition that is contained in paragraph 2 of your employment contract.
Yes.
And it states that the offer of appointment is subject to you obtaining the top secret security clearance from the State Security Agency. And should your dismissal from the Department of Rural Development and Land Reform be confirmed by the Labour Court, the contract shall terminate on the date of the court order unless the employer decides otherwise after having studied the judgment.
Yes, correct.
Correct?
Yeah.
And your employment in the first fixed term contract, did it have the same condition?
I think so.
Yeah. And then if you look at paragraph 3, they ask you for a confirmation that there's no representation that you would be employed beyond the termination date. In paragraph 3, on the part of the employer.
Yes.
Right? And then if you go further on, and effectively you're the accounting officer, correct?
Yes.
Right? If you go further on in paragraph 9.2 on 1460,
Okay. Right.
right? We will see that your appointment is subject to in paragraph 9.2.2,
Mhm.
just one up, 9.2.2,
Mhm.
obtaining the top secret security clearance from the State Security Agency, and that both parties agree that failure to obtain a top secret security clearance will result in the termination of the appointment.
Mhm.
Correct?
Yes.
And then similarly in 9.2.5, it
Mhm.
said, should a dismissal be confirmed by the Labour Court, the Public Protector shall review the appointment, which review may include summary termination of employment.
Yes.
Correct?
Mhm.
And clause 10 puts you on probation for 10, and then your paragraph 14 on 1464.
Mhm. Paragraph.
14 is your confidentiality clause. By accepting the offer of employment, you acknowledge and agree that you will not, during the course of your employment or thereafter, except for the consent of the employer as required by law,
Yes.
or in the performance of your duties, use or disclose confidential information relating to the business of the employee, including but not limited to client lists, trade secrets, client details, and pricing structures. Do you see that?
Mhm.
So slightly not appropriate in the sense that you didn't really get involved in pricing structures and client details, correct?
Yes.
Okay. And you then, at the end of this, you accepted this offer, correct?
Yes.
And then near the end of that period, you then concluded a fixed term contract with the Public Protector which for the remaining period of 1 August 2019 until her end of term, or roughly the 30 April 2023, or the end of the financial year.
Mhm.
I think her term ends a few months later, correct?
Mhm.
Right.
Yes.
And you were tasked to be the accounting officer and to provide support to both the Public Protector and the Deputy Public Protector.
Yes,
correct?
correct.
All right. So we're back to your affidavit at page 2721.
Page 2.
721. You were not involved in the ongoing. Let me give you a moment. Paragraph 14.
Yes, I'm there.
There were various court cases going on at the
Yes.
time you joined the PPSA, correct?
Yes. Yeah.
And there were other court cases that commenced during your tenure.
Yes.
Were you involved in any litigation, decision-making or strategic decisions in respect of litigation?
No.
Were you involved in the selection of any particular attorney or advocate on any particular case?
No. But maybe that needs to be explained. What administratively, what will happen if the resources of the organizations are going to be used? I will need to be informed in the form of a memo, which I need to approve. Obviously, the rationale will have been documented in the memo that comes to me. So it's part of supporting the core business.
So there would be a memo, for instance, on the appointment of ex-attorneys. You would be informed it's for that case. There would be a route form probably from the legal advisor right up to you, and you would then sign off on it.
Yes.
Right. Now, at the time when you joined the senior manager legal services was Mr. Nemasisi, correct?
Yes, the legal service head was Mr. Nemasisi.
And he was then resigned and he was replaced by Mr. Alfred Mshlongo.
Yes, correct.
There was a public furor that arose about your appointment to the Public Protector's Office because of the circumstances of your dismissal from the department, correct?
Yes, I think we went on length when we were explaining the charges and also the prohibition matters. Those was around it because some people felt that it's still not enough that I'm eligible. But I mean, there was nothing that was prohibiting me at that time to join the Public Protector South Africa.
And you had made a full disclosure of at the time of your interview, and you were appropriately qualified to take on the job.
Yes.
Right. So you were aware at the time when you applied for the job that you would require security clearance.
Yes.
Did the advertisement indicate that you require top secret security clearance?
The advert, just like any other government department or parastatal, it refers to the requirement that you'll be expected after a certain number of months to obtain the security clearance. Then later, when you are in the organization, that's when they specify which kind of security clearance they need, depending on your position. But they don't put that normally in the advert to say it will be top or normal security clearance. You will only know once you conclude the contract. They will direct you which kind of security clearance they desire.
Right. And you were informed at the time that you did the application for the security clearance. And if you look at page 2746, you subsequently, I think it's dated 31 October 2018.
Yes.
Right?
Yes, I got it.
You were informed that the security clearance investigation had been conducted and that because of your prior dismissal, in paragraph 3, the state security agency cannot at that time make a determination of the security clearance. And it was requested that the appeal process be given a chance to be finalized.
Yes.
And the results could then be forwarded to the SSA immediately, after which they would make a determination.
Yes.
So in effect, you didn't have top secret security clearance.
Yes.
right? And until your matter in the labor court
It's finalized.
was finalized in your favor, I presume that
Yes.
would be the position that prevailed.
The state security doesn't mention whether in my favor or not, but they just said, let's allow it to be concluded. Then we can reconsider
That's
the
correct.
application. Yes.
Right? But the public protectors, if the labor court had dismissed your application and you were refused top secret security clearance, you then wouldn't have been eligible for employment at the public protector's office.
Technically, it says so.
Because it was a condition of their employment irrespective.
Yes.
Now, which meetings at the public protector's office did you attend?
We had our expo.
Sorry, Advocate Bauer and Mr. Maslang, I see your staff is upside down. Is that a sign that it's a factor fault, it can't be fixed? So we now need to turn our heads trying to read it.
No, go to view.
What is being flighted?
Okay.
You not upside down and I'm Mexico.
Not yet.
I saw.
On the view. Then I say to you.
It's getting there. Did you get it? I saw you almost giving up. So, but you proceed. You're about to respond, Mr. Mahlangu. I don't know if you still remember or you want Advocate Bauer to repeat.
If I can be assisted with the question, Chair.
Sure.
I asked you which meetings within the organization did you attend?
We had, I think there were 3 of them. It was an exco where it will be the public protector and the deputy public protector and myself. Then there will be another level where it includes executive management teams that will involve the heads of investigations, the legal, and then the chief financial officer. And then there will be a separate one that is mainly case management, which is called a dashboard.
Right. And although these meetings dealt with case management and investigations, and so did you have any role to play?
Just repeat the question, sorry.
In the dashboard meetings, which dealt with case management,
Yes.
or which related to the various investigations, correct?
Yes, it's basically where they will give stock of where they are. They are basically not discussing the content of the investigations, but where they are and the resources that they will need for them to finalize their case. So that administratively we can ensure that there's necessary tools of trade for them to do their work.
Right. And so you would provide the administrative support, the finance person would be there to deal with financial and procurement matters, and the legal person would deal with legal matters.
Yes, correct.
And was there a COO at the time you were there?
There was in my first few months, there was an acting COO, and then later we appointed Ms. Basani Baloyi as the COO.
Oh, Ms. Basani Baloyi.
Yes.
Right. And what was the role of the COO?
The COO basically was the head of the investigations, all this, the executive manager's investigations, they were reporting to her. So she will be the one making reports when we go to executive management meetings about the performance of her teams.
The executive managers now shortly investigation was in the CEO to whom they would have to answer.
So if the executive managers fail to perform any of their responsibilities or fell short, would they then answer to the COO?
Yes.
Now, I'm going to take you to some of the individual cases which emanate from charge 4. And let's start with that of Mr. Samuel. And this issue came to your attention because of a summons that had been issued against the PPSA for an amount of 350,000 emanating from an altercation that had occurred when Mr. Samuel was at the Limpopo office, correct?
Yes.
Right. And at the time, the information available to you was that he had paid an admission of guilt fine ensuing from the result of the altercation.
Yes.
How did this come to your attention? And when?
Well, I wouldn't remember the exact period, but what is happening is that in your finance reports, you will be given the status of the budget, and then you will be told about liabilities that comes that are there that needs to be. Maybe let me put it like this: with just like any other government department, with biggest problems around the budgets in the PPSA. So with serious cost-containing measures, and one of the issues that we need to do, we needed to clean our books to see what are the things that are affordable, what are the things that are not affordable. Then later in the process, we pick up that we've got other liabilities that cannot be explained, but maybe I'll talk to that later. Maybe just to be specific on your case. Legal services brought to our attention that we had been sued for 350,000. And then we started asking questions, but what is it for? And then it turns out that it's an old matter of 2011 involving one of our officials. Then the next thing that needed to happen at that time was for HR to give us a report about how was this matter handled previously by people who were there before us. There was no tangible documentation or information that talks to how they handled this matter. So it was basically a word of mouth to say that the matter was reported to the organization. Mr. Samuel paid the fine, and that's where it ended. But Chair, it couldn't just end like that, because in terms of the PFMA, the accounting officer has the responsibility to ensure that there's no expenditure that is unexplained, or maybe just a matter that there are allegations within the organizations and there are no consequence management. I had to take a decision to say, if we lose the case of the 350,000, how am I going to justify the payment of that litigation? The best thing was to subject Mr. Samuel to a disciplinary process, because there was no prior record of how the matter was handled. So it's like people who were there were very lax in dealing with this matter. They could have just kept an audit trail so that whoever comes in can satisfy him or herself that this matter was dealt with thorough, and Mr. Samuel, his punishment was done, there was consequence management, let's just deal with the litigation per se. So I subjected Mr. Samuel to a disciplinary process just to ensure that the person will get a proper advice about how best to deal with this matter.
Mr. Mahlangu, you only served at the Public Protector's Office until the end of December 2019, correct?
No.
Sorry. You resigned from your position as CEO with effect from 1 January 2020.
Yes.
The charges were only brought against Mr. Samuel after February 2020. So that was after you had left.
You maybe just check proper because I think there were 2 charges against Mr. Samuel, but the first charge, which relates to the assault, was done during my time. It might not have been signed then, but it was done in my time because it came to my attention and I had to deal with it. If there's any charge that was signed thereafter, it could be another charge, but not the.
He was charged in one proceedings with everything. He wasn't charged separately with the assault and then separately. In fact, the assault was raised part and parcel with the other charges after you had left. There was no disciplinary proceedings during your tenure as CEO against him. That was, it struck me, that was part of Mr. Samuel's complaint, was that the charge of assault was actually only brought against him after he had complained, or after he had written the letter to the speaker, that although there was an investigation and it had been questioned and it was raised with him by the head of HR prior thereto, the actual charge sheet only arrives after his letter to the speaker. By then you had left, right?
Chair, let me not dispute what the evidence leader is saying, but what is of importance here is that when the assault case emerges, I was there and I issued the instruction. Whether at that time the charge sheet was ready before when I was still there or I left is another thing. We can verify that maybe with the people who are still in the organization, but the matter was brought during my tenure.
No, that is so. I'm not disputing that, Mr. Mashangu. You didn't speak with Mr. Samuels at all?
No, I never spoken to Mr. Samuel.
Who did Mr. Samuels report to at that stage?
At that time, I think it was Basani.
Did you speak to, was it, if he was a provincial representative, would he have answered to the EM or to the CEO?
It's either it was Basani or no, but whoever was in charge was also accountable to me.
Right.
Yeah.
Did you speak to either one, Ndo or Basani, about it?
I could have spoken to one of the two.
Okay.
But the driver of the charges and the advice, it was from legal services.
It was legal services.
Yes.
Yeah. And Mr. Samuel and Mr. Yalele will give evidence of this later, but I think you do have knowledge of it. There was nothing in his HR file indicating any misconduct on his part, correct?
Chair, maybe with your permission, can this be subject for verification? Because I think I played a role there. So.
Yes. Sorry, what did you say, Mr.
I was saying maybe this should be flagged as a subject for verification during break.
So you didn't check his HR file?
No, I didn't check his, but I asked for information, which Mr. Chilla didn't give me something that was convincing.
And from who did you get information?
Mr. Kumbi.
Mr. Kumbi.
Yes.
It's Kumbi Chialela, right?
Yeah.
I also call him Mr. Kumbi sometimes.
Yeah.
And so we'll flag that for me.
Yes.
He comes and gives evidence.
Sure.
But so the only information you obtained was from him?
No, remember it was brought, your earlier question was about how it emerged.
Yes.
It came from the legal services because all litigations are channeled to legal services. Then after it came from the legal services, the first thing that you do as an accounting officer, you ask HR to give you a report about how this matter was handled before. But the report that came from Mr. Gumbi was not convincing. So I had to start my own disciplinary process in order to correct this.
You say the report that came from him was not convincing.
Yes.
If I take you to 23.3 of your affidavit at 2724,
2724. Okay. And then,
Right? You say, to the best of your recollection, I was not apprised of any steps having previously been taken or Mr. Samuels' assault charge and conviction having been discussed and resolved with the previous PP and EXCO as alleged by Mr. Samuels in his affidavit to the speaker, and there was nothing put before me to suggest that the matter had already been dealt with by the relevant authorities to the PPSA.
correct. This is where the problem started, because there was no proof that the relevant authorities took a necessary step to correct this matter.
But did you endeavor to get hold of your predecessor who had been the CEO at that stage?
Well, Chair, because there were people in the organization, especially the HR, I rely on them. I didn't find it necessary, or it didn't come to my mind that I must call people who have left the organization for the information. All organizations keep information so that the new people that come, they easily access the information and run the organization. So there was no need for me.
But you can't discount the fact that it was dealt with internally at the time.
Well, I wouldn't argue.
And it may well be that it was recorded in the meetings or whatever EXCO existed at the time,
It could be,
but it just wasn't made available to you.
yes.
And during your tenure, the manager of security, Mr. Baldwin Nshunzi, right, was also put on suspension relating to the leakage of documentation and information
Yes,
that had been received from the office of the president at the time.
yes.
And in respect of that, he was placed on suspension. Why was he put on suspension, Mr. Maslango?
We're investigating activities in his office. So I felt that maybe we should just take a step back so that we conclude the investigation.
That was the position adopted with other employees as well. I think when Miss Mohaladi, Mr. Madiba and
The city,
was investigated, they were also placed on suspension,
yes.
correct? And that investigation then ensued. We'll come back to that in a moment. Now, Mr. Nshunzi, in fact, as it turned out, that investigation on the leak he was exonerated and he then returned to office, correct?
Yes, actually, Chair, maybe we'll get to that, but I don't know how people perceive a disciplinary process. To me, a disciplinary process is not to say that you are guilty, but is for us to satisfy ourselves that it's either we have done something wrong or not. And then if it turns out that you are innocent, and then you will come back to work. And that is the case with Mr. Nations. It was never a foregone conclusion that you will be subjected to a disciplinary process and then expect the worst. You're going to be fired after that. No, it was just for a fact-finding mission. And later it turns out that, yes, he's got his weaknesses there and there, but doesn't warrant him to lose his job. And that's why he came back to work.
And you accept that disciplinary process you describe requires an engagement with the employee as part of that process?
Yes.
Right. There was then an issue around the same time relating to the leakage of the information that you were not in possession of a security clearance documentation, correct?
Yes.
Right. And this too was investigated by HR together with legal services.
Yes.
right? And there was then a decision taken that an external consultant would come in to conduct the investigation, and a report would then be prepared by them.
Yes.
Correct? Now, I'm going to come to that report in a moment. I'm going to deal with it after the tea adjournment. I just want to take you through the other persons, and then I'm going to come to this report.
Okay.
At the time of your employment and linked to this leakage of information, the disciplinary processes in relation to Mr. Kakana also arose.
Yes.
Right? And that related to a disclosure of information pertaining inter alia to documents emanating from the Minister of Finance, as well as documentation pertaining to a trip that you were undertaking together with the Public Protector. Correct?
Yes.
And we'll come in a moment to the details of those travel authorizations. But effectively, let me maybe deal with it now. It appears that in documentation in an email, the personal assistant was left to either the person it was left to the PAs in your office and that of the Public Protector to sort out the travel arrangements, and that in respect of preparing that documents, which was for a international association of ombudsman meeting that was to take place in Rwanda.
Yes.
In the preparation of that documents, it had incorrectly reflected what the purpose of the trip was.
Yes.
And that document then came to find its way in the hands of Mr. Kakana through an email communication, correct?
Yes.
Did you go on that trip?
Yes, but let's put a context here so that maybe members understand what's happening. From time to time, you will have the Public Protector will have international engagement. At that time, she was the president of the ombudsman in Africa. So I think we had a trip. Maybe the trip was to present the annual report here in Cape Town. Then the next trip, we were going to Rwanda on that international duty. But the PA, between the PP office and my office, one of the juniors, instead of doing her job proper, just made a chop and paste about a traveling trip. The trip was talking to an international trip. The form was talking to an international trip, but the content was something else. Whereas my PA was, this person happened to be Tebogo, who's in the office. I think it's finance. And then when my PA sent the requisition, it went to Mr. Kekane. Mr. Kekane, as a colleague of my PA, instead of just saying, I think we have sent a wrong document to me, but took it upon himself to go through what is this information about, and then start making allegations to say, oh, I've intercepted information whereby Mr. Mahlangu is lying about a trip to Rwanda instead of Cape Town also. So that's how this transpired. That was true.
There was then the issue arising in relation to Mr. Isaac Matlawe.
Yes.
Correct?
Yes.
And what was your first encounter with Mr. Matlawe was at the meeting when the Public Protector introduced you to the staff at the PPSA office, correct?
Yes.
And what transpired at that meeting?
Chair, when I was introduced to the staff I had to, the public protector introduced me, gave a background about who I am and what are my primary responsibilities. And then later I was given the opportunity to explain my experience and how best am I going to take the organization forward. And then later it was question and answers. Mr. Matlawe was one of those people who raised their hand and asked a question, but he was very upfront. He spoke about, but we know Mr. Mahlangu's history. Actually, I think a week before I came, there was a City Press article that he referred to about Fari, about my appointment, and then the public protector explained the situation and the conditions upon which I was appointed, and what are the expectations from the organization, especially in relation to the court case, as stated in the contract, that if things doesn't go my way, the contract will be terminated immediately. He was not happy, but the matter at that time, we all accepted that, yes, there is an issue, but Mr. Mahlangu will have to deal with that, but that didn't impede on Mr. Mahlangu to perform his duties or prohibition the eligibility to be in the organization. And maybe for your information, I found out that Mr. Matlawe is a representative of the PSA, which is the union. And then later I realized that, but this comes naturally with his work as a representative of the workers to make sure that the things are clarified. So there was never an issue in harmonicity. We just carry on and work in the organization together.
Right. And Mr. Matlawe was subsequently also implicated in the leakage of confidential documentation.
And there's a step that you are jumping, but I can confirm that. Then from time to time, Chair, the public protector will have what we call outreach programs. We'll visit the different provinces, take stock of their performance, how they are handling complaints, and the communities, some communities will attend and voice their unhappiness about the slowness of the office or how their complaints are not attended and all the stuff. In one meeting, I think it was in the Free State, and Mr. Matlawe was also present when we were meeting the management team of the Free State office. Out of the blue, when we were discussing the state of the office, then he started repeating the very same things that he said when I was first introduced to the organization. And again, it never became personal. I just accepted again to say, well, he's supposed to be vocal because maybe it's how they operate within the movements, especially the Public Servants Association. So we just let the matter go away. Now, on this one, so I can explain maybe further this one after the evidence leader has asked a follow-up question.
No, it's fine, continue.
Okay. Oh, I can continue.
Yeah, yeah.
Okay. Now, unfortunately, Chair, on this one, I think it's number 28. And when it's linked to the investigation of the unit of Mr. Nechunzi. So when we're investigating this leakage of information, because now there were also negative publicity about the public protector giving information to the public about the complainants or people that are being investigated. I think in particular the Section 79, because they are confidential, so the information was all over the show. As an accounting officer, I had to put some measures or check what's really causing, where is the source of these leakages, and then where to bring external people And then you will know in investigation, Chair, that there might be a need that they take your computers, your gadgets, and all the stuff. Because I'm specifying this because it was all over in the news that people that are unknown put their laptops of the staff and all the stuff. But it was part of the investigation. They wouldn't have concluded the investigation if they didn't go through that process. But the gist of the matter here is that later it turns out that the sharing of unauthorized information, I won't say specifically about the president and them, but other information that come up there was between Mr. Kekane and Mr. Matlawa. So that led to the two being charged. So it's got nothing to do with what they've said about, I wouldn't want to get into the issues that they mentioned. There's the correlation or the relationship between a particular investigation and them being charged. Here, I was just doing my pure administrative work, unless they want to come and prove it differently. But they've already spoken, I've listened, there's no such. The investigation on Mr. Kekane and Mr. Matlawa was purely from the report that where we brought an outside person to investigate the leakage of the information. So that's why it is with me. So yeah, that's it, Chair.
Mr. Matlawi, however, left the employ of the PPSA to join the bar as an advocate prior to his disciplinary proceedings running to fruition. Is that correct?
Mr. Matlawa left the employment, but to say where he went, I don't know. I didn't know.
Okay. So are you aware of a letter that had been addressed to the Bar Council?
No.
You didn't send such a letter?
No.
And you have no knowledge of such letter?
No.
Then the other disciplinary matter related to Ms. Ponachego Mukhaladi, Mr. Abongile Madiba, and Mr. Sedi Sikeri, who was also listed in the fourth complaint. And this related to what is described as negligence in respect of the preparation of a Rule 53 record in the matter of the Financial Sector Conduct Authority involving Advocate Shidi. Correct?
Yes.
In respect of an incomplete record.
Yes.
How did this come to your attention?
Again, this one, to my recollection, is one of those matters whereby the public protector was threatened with the personal cost, because every time apparently the complainant will insist that he has provided all the necessary, the requested information from him. But within the organization, the investigator in particular, I think between, I think it's Lady Karina and Lesedi, they insisted also that they've never researched, they received the necessary documentation for them to see whether there's a case or no case. The matter dragged for long, but for some time, when we were busy cleaning the filing in all the offices, there was confession that they find the information that this complainant was busy referring to after compromising the organization. It was discussed in dashboard. You asked the question how it came to my attention. It was discussed in dashboard. We noted it. And then after they've confessed or finding those particular documentation, then the disciplinary process started.
But there was no disciplinary process taken against the person, the one employee who gave evidence, Ms. Karina Van Heerden.
Well, let's maybe look around the hierarchy of the organization and how disciplinary processes are conducted. At my level, I will deal with a particular executive who will then deal with the lower one, and then up until it gets to the real culprit. Remember, I explained how I view disciplinary processes. Mine was to deal with those that I have close proximity to in terms of the hierarchy, which was Bona, Madiba, and Lesedi. For them, it was for them to prove to the organization to say this is not their making, but they were misled by their junior, and then we'll take it from there. I don't think they've done that because I left at the charge stage. So when the disciplinary hearing started, I was not there. If they presented to whoever was a chairperson to say that, but as much as we were saying we don't have this information, it looks like our junior was the one is at fault who never brought this to our attention. That's my understanding of how the things unraveled at that time, or how they were supposed to handle the matter.
So it wasn't the case of because there was a dereliction of duty specifically in respect of a case that it came to your attention.
But if you, the manager, and you fail to manage your subordinates, that can be dereliction of duty, because it was upon them to ensure that they get that information and find out how did the information came from the complainant to the organization and where would have the information disappeared. But they couldn't get that information, and later it turns out that the information is lying somewhere with their junior. So it becomes their fault. So they fail to manage.
So as I understand the disciplinary hierarchy, you would deal with senior management, and senior management would have to deal with those below them.
Yes.
Who reported to them.
Yes.
Except in the case of Mr. Samuel, it went directly to you.
No, it didn't go directly to me. The Mr. Samuel issue came from legal services. It went to HR to provide the report. And then remember, we said we're packing the fact of saying who charged Mr. Samuel later. So we'll come back to that. But there's nothing unique in the handling of Mr. Samuel's case and other disciplinary cases.
Right. So the further, and I must put this to you because both Ms. Baloy and Mr. Matlawe is going to come and give evidence at some point, and I don't want it then to be left to the committee to say that we should have asked Mr. Mashlangu these questions. So I'm going to put to you some of the propositions that emanate from the court papers of Ms. Baloy. She was employed for a probation as the CEO on a probationary period of 6 months, correct?
Yes.
She answered in part to you and in part to the public protector.
Yes.
Correct? And you then had what you called a review meeting at 8 months, not 6 months due to practicalities.
Yes.
And you assessed that she was not performing and her contract was not the employment was terminated.
Yes.
Correct?
Okay. Yes.
And we know that that was then taken on review. It went right up to the Constitutional Court on a procedural matter. The Constitutional Court ruled in her favor, and the matter is now pending at the Labour Court. High Court or Labour Court?
Yes.
At the High Court. And those events occurred after you left the Public Protector's office, correct?
Yes. Yes.
Right. So what Ms. Baloy does is she Chair, do you want to take the adjournment now? It might be a good time. Not that I'm almost, but I think it might be good to, I want to get to the report and this, but if you want to take the adjournment now, I could do this after the tea break and then we could put it on the screen.
As long as you know that after you'll be left with 15 minutes. Or you want me to add these other? Okay.
Sure, I must get
That's
15 minutes.
That's fine. Thank you, Advocate Bauer. Thank you. With that request, it's 11:20. We will take an early tea break and we'll be back at 25 to 12, and then Advocate Bar will take from there and complete her work. We pause here just for tea.
Recording
Thank you, colleagues.
stopped. Chairperson, Chabalala here. I hear you loud and clear. Nemadinga.
I'm speaking to Advocate Chabalala, not Honorable
I
Nemadzinga
see.
Chabalala.
Sorry.
I said,
Sorry.
please.
Okay.
Advocate Chabalala. We can't hear you. Please fix that. I can see you talking, but the audio is not coming through. Fortunately, we're not with you now, but try to fix it in the meantime. Thank you. Advocate Bauer. We still can't hear you. Just try and fix it in the meantime. Advocate Bauer.
Okay. Mr. Mashlanga, I'm going to put up on the screen a couple of paragraphs in the affidavit of Ms. Beloy to give you an opportunity to comment in respect thereof. Ms. Beloy has not yet given evidence and the matter is still pending in court. We're aware of it. So if you wish to answer in general terms, then so be it. You and she are agreed. I want to take you to paragraph 20. I think you and she is agreed that there's no role for the CEO in the process of investigations and you're not concerned with the merits of investigations at all. Would you agree with that?
Yes.
Right. She, however, says that she cited you and the she makes certain themes in her complaints against you in the affidavit, and I'll put them in general terms because of this. One, that you interfered in investigations, even though your role as CEO meant that you played no part in investigations. And in particular, in her affidavit, she mentions an investigation into the minister whom you answered to in the Department of Land Affairs, Minister Quinty. Can you comment on that?
Sure. There's, with due respect, I think there's two issues here. I don't know if the evidence leader can find the specific sentences because in my study of these documents, I came across that. Maybe we should go there, zoom in there, so that it's not general.
Let's just do that.
Yes.
I put it as a general question because I thought you wouldn't want to answer specific allegations, but
once I see it, I'll decide whether to answer or not.
That's fair. It will be done.
paragraph 40 headed the M20 investigation. These are the High Court papers, Mr. Mashlanga, not the Constitutional Court ones. Go down. This relates to the M20 investigation. Further, 40, 42, 45. Wait. The CEO came to me and asked why let's go up to 42 first so that we have a context. Mr. Mashlanga serves as a CEO. He was charged with misconduct and I attach a copy. He was subsequently employed, notwithstanding his dismissal. And she says it's for dishonesty, but we've covered that. 44. I received a draft report from the senior investigator. The chief investigator said that the report would have to be done differently. The CEO, you were the CEO at the time, is that correct? Came to me and asked me why I was mistreating the senior investigator. He demanded that I exclude references to the draft Deloitte report and other relevant information. I was also disturbed to learn that he had also raised the matter with the chief investigator and executive manager. I viewed his conduct as a classic case of interference, given that he was conflicted. Based on this experience, I convened a think tank to review the report. The CEO believed my conduct was designed to embarrass him. Go down. However, this was untrue. I was merely doing my job in enriching the content of the report. I have convened similar meetings to deal with reports such as the Mpumalanga Premiers Vehicle, the Mpumalanga Mandela Memorial and the Free State website, and I have no intention to embarrass him. Let me then go on to paragraph 47. Right. As I explained above, the CEO is not supposed to be involved in investigations. His role is administrative. It was highly unusual and improper for him to seek to be involved in an investigation that implicates him.
Okay, we can go from, I think, 40. I would like to go one by one. so that I don't give a blanket response of no comment or no. The 40, Chair, it's true. That's how events unfolded with the back and flame matter. So we can go to the next one. And also 41, it's the next natural process that the department took after the allegations surfaces. And then 42, we spoke at length. We even went to the charges. So yes, that's how it also unfolded. Then 43 also, we spoke about it earlier. Then 44, I only know. So maybe let me leave it at that, because this is what she's saying that I don't know about that. And 45, I won't comment because I don't know about that. Also 46, I don't know about that. Partly 47, she's reiterating that I'm not supposed to be involved. Yes, I'm not involved. So all the above that is speaking about me asking this and that, I don't agree. So don't even have to comment about it. 48, I don't know, because it looks like it's a discussions between herself and the public protector. So I was not party to that discussion.
I only took you up to 2047 because
okay.
I don't think I can ask you about things.
Okay. No, thanks. That's all true.
So in 24 of the affidavit, paragraph 24 of the affidavit, she 22, right? At some point, I believe I was seen as a stumbling block at the office. The CEO, in fact, once informed me that we would get me. I shall set out some reasons that I believe are being improperly to get rid of me, which I believe is a mere pretext, my right. And then Mr. Shango, what she then sets out in 47 onwards is emanating from 24. Have you got a comment about that?
I don't remember that conversation.
Mr. Mashango, before you met with her at the 8 months period, on her probationary period, did you raise any aspects with her prior thereto about her failure to perform, any incompetence, any misconduct? Did you raise any of that with her prior to that meeting?
Yes, what was happening, remember, we will attend several meetings with her. I've mentioned, I think I didn't mention all of them because I can't remember all the names, but in particular the dashboard and the exco, where the matters are being discussed, and then there will be exchange of views between herself and the public protector. Remember, when I'm sitting there, I need to identify the gaps and how best to provide support to all the units. So from time to time, there will be the issues that the executive authority will raise about the investigations and how they are performing and all the stuff. And then those will inform our discussions out of the meeting when we discuss her unit.
Do you recall ever sending her anything in writing?
Do I recall sending?
Do you recall sending her anything in writing?
Around performance?
Yes.
No, I don't remember sending anything around performance because we'll have our meetings where we'll agree on things and then she will go and do exactly what, or go and try and do improve on the areas that I've picked up.
Now, if I come back to Mr. Isaac Matlawe, his affidavit is not yet before the committee, but I'm going to broadly put the allegation to you.
Yes.
He was served with a letter of suspension on 4 December 2018 after he had already resigned. Are you aware of that?
After a year that he resigned.
after he had already submitted his resignation.
Sorry, Chair,
Mr. Matlawi submitted his resignation.
in 4 December,
No, on 1 December.
1 December, yes.
On 4 December, he was served with a letter of suspension.
Well, the chronological order of the dates, I may not be sure about it, but I can confirm that we sent a letter of disciplinary to Mr. Matlawi. Whether he had resigned at that time is another thing.
So you're not sure whether he had already resigned before you sent the suspension?
If he had resigned, then I was not informed that Mr. Matlawi has resigned.
So on the basis that his suspension letter is actually served on him after he had resigned, he regarded the proceedings to be pursued as a form of persecution to cause him some distress. Do you want to comment on that?
Chair, maybe let's take a step backwards. I explained earlier that you, in an organization, you follow a certain process. In government, under normal circumstances, if there's an issue, you refer it to a relevant unit. Like in this case, it's a HR matter. If there's a complaint about a certain Mr. Mahlangu, you will inform HR to say there's this complaint, can you please generate a memo or investigate and then tell me advise me exactly what needs to be done. I will assume that in the case of Matlawi, when they were busy preparing the memos, maybe he knew that there's a memo coming or the letter to suspend him on his way, and then he decided to proactively resign. But now that's where the HR comes in. The HR will be the first custodian of receiving the letter of resignation. They might as well come to me and say, but this is just an academic exercise. That person has already resigned. So you may want to dig deeper to say, why would the HR have a resignation letter of a particular individual, but still process the suspension of that person, whereas the person has already resigned?
Well, that's precisely his difficulty in that.
It's also my difficulty. Chair.
Mr. Mahlangu, so let me say, being part of the profession, if it commenced pupillage on 1 January, then he would have been accepted into that program months prior to any, it wouldn't simply have happened in December or November. He would have known months prior thereto that he would be commencing pupillage on 1 January. I'm putting that to you because you raised the issue of, could he have resigned knowing that disciplinary charges was coming? And that's understandable because it does happen. But in the context of Mr. Matlawi, he was already accepted into a program, and it's only fair that I put that to you. He then goes on that he says he was then not given sufficient notice of the disciplinary proceedings, and the charges was then served on him on the 18th of December, or the disciplinary inquiry to commence on the 21st of December.
Yeah, okay. Again, once I've authorized the investigation, I will know, okay, let me say in this case, once I authorize the disciplinary action, I will know going forward between legal services and the HR how they've handled that. But under normal circumstances, those are the things that whoever is being charged will have the opportunity to present to the chairperson of the disciplinary process to say, but you see, this is how these people are treating me. You see, so Matlawi had all the right and the opportunity to talk to whoever was chairing the disciplinary process about how the organization was treating him. So it's up to the chairperson now to pronounce on that process, the fraud of the process of the disciplinary process.
I think his objection was that he was entitled to 5 days notice, but he got the notice on the 18th for it to be set down on the 21st of December, during a period where I think when do the offices would close shortly thereafter? Is that be correct?
I wouldn't remember all those, but I'm saying, Chair, he had a recourse. He had a recourse. Those are the things that he was supposed to put to the disciplinary process to ask people to say, but how am I being treated like this? And the chair of that process was supposed to pronounce on that. If anything needed to be corrected, I mean, the organization was supposed to redo the whole thing so that the process is regular.
So Mr. Matlawi then says the disciplinary process against him, which he contested, was pursued with zeal and motivated with malice for the following. He had already resigned. He was serving out his notice to the end of December, and he was being hauled before a disciplinary inquiry on 21 December when the offices had already been closed for the holidays, and then again on the 27th of December, to which date it was postponed after he fell ill. You wish to comment on that?
No, what's zeal? We spoke at length about how Matlawi's conduct was and how the accounting officer just turned a blind eye about his conduct. Up until later, he scored his own goal during the investigation of the leak of information, and then he got charged. There was never a zeal, but there was a process that was followed up until he was found to have violated certain issues within the organization. So I don't know where does the zeal come in there. All the process was followed. If he wants the new issues that we are bringing, I respect what he's saying without factual information. But the reality is that there was a process that was followed up until he got charged. We didn't just bring up charges from nowhere. Whether how the process was regular or irregular once received the charges up until to the disciplinary process, I think the evidence leaders may have to take that up with the organization and just satisfy themselves if why Matlawi was pursued around that time and after he has already resigned.
Okay. So I'm simply putting to you the allegations made, Mr. Mahlangu. So
okay,
don't shoot the messenger.
Sorry, Chair.
I want to take you to the report that had been done by Diallo Mogashule, and I'm going to take you to the report, and I've got four questions thereafter, and I'm saying that because I'm watching my 7 minutes plus my 10 for tea time.
I think you said Diale and something, and I saw the chairperson raising his head.
I've forgotten the name. I think it's Diale Mogashua. Mogashua.
Yeah.
Right. I apologize.
Sure.
Mogashua. Right. Okay, so if we go to page, and I'm going to take you through it very quickly. I'm going to, and not deal with all the allegations in the report because the members can read it for themselves. At page 1369, maybe you must just, yeah, okay. Go to paragraph 2, it will tell you what the scope of the investigation. So it arose in March 2019 when they were appointed to conduct an independent investigation into Security Management Services Unit and submit a report of findings and recommendations, correct?
Yes.
They then set out the scope of the mandate, which was to investigate the leakage of confidential and sensitive information contained in an email sent to Advocate Mkubani on 10 December by Mr. Matlawi, a former employee and shop steward, and to investigate and define the job content for the Security Management Service in the context of management of information security, National Strategic Intelligence Act and systems, as well as the PPSA Security Services Policy, and propose distinct work plan jobs, right?
Yes.
And then 2.23, which I don't think materialized, was to represent the PPSA in disciplinary hearings following thereon. And they then set out how they conduct the investigation, and we're going to skip through the structure, limitations, and qualifications. They then come to relevant factual background, and they deal with your appointment in paragraph 5, where they point out that all successful candidates will have to undergo security clearance and vetting, and competency assessments may be conducted. You agreed with that?
Yes.
All right. You were then appointed on an interim basis with effect from 1 May. You then in paragraph 5.3 deals with what occurred in the meeting which took place, to which you already testified, at which Mr. Matlawi raised the concerns of your appointment. And it basically says there that he raised the concerns relating to the appointment of the CEO without a security clearance, given that he will be handling sensitive information. And they responded that they were informed that in a response, the public protector indicated that it was for that reason that you were appointed on an interim basis. Correct?
Yes.
Right. They then note that your fixed term contract was then extended from 1 August 2018 to 31 July 2019. And then Advocate Mkubani in 5.5 received an email from Mr. Matlawi titled Complaint, Maladministration and Nepotism in the Public Protector. And it sets out the nub of this email, that the position of executive manager, stakeholder management and customer services was never advertised, and that the incumbent, who was the sole candidate interviewed to the position, was a friend of the public protector, that the former chief of staff, acting chief of staff, did not have qualifications, that upon the expiry of the former special advisor, the PP personally instructed the security manager to process his application for security clearance, that the CEO had been appointed on a 1-year contract was unable to obtain a security clearance due to his pending matter at the Labour Court. The suitability was raised at the staff meeting, and despite cost containment measures announced by the CEO, the public protector travelled with the CEO and the former chief of staff to Rwanda on business not related to the PPSA, but OMA business. CEO's trip authority indicated that the CEO was attending the PPSA strategic planning. And that last sentence was the error that was made in the documentation by the PA. Instead of identifying it as AOMA business, it was identified as PPSA strategic business, correct?
Yes.
Right. So the two issues which Mr. Matlawi complained about relating to you was the fact that you continued in your position despite having no security clearance, and that despite putting cost containment measures in place, you were traveling overseas with the public protector and the former chief of staff. And you already explained the context of which you accompanied her to Rwanda, correct?
Yes.
Okay. And it then, the concern was then raised in paragraph 7 that as a consequence of this email, he had knowledge of confidential information of the PPSA executives. I'm at paragraph 5.7, sorry. The CEO addressed a letter to Mr. Nshunzi. Mr. Nshunzi was then the senior manager of security management, in terms of which he was advised and asked to look at how that came about, correct? Right.
Yes.
Mr. Nshunzi was then suspended pending the investigation.
Yes.
Right. He was then reinstated afterwards when he was exonerated from that investigation. And maybe I must stop at 6.7 in the report, because you had alluded to that earlier on. It basically shows who they interviewed. 6.7 was the seizure of the computers from various people as part of this investigation, correct?
Yes.
Mr. Kakana testified, Mr. Mashlango, that when he got his computer back, certain emails had been wiped off the computer. Do you know anything about that?
No, he never reported to me that, but we saw it in the media and all of that.
If I then take you to And at that stage, it was Mr. Nshunzi that liaised directly with the State Security Agency to conduct the security vetting on behalf of the PPSA, correct?
Just repeat that. Which
It was
point?
Mr. Nshunzi that liaised, it's paragraph 8.1.23.
You don't repeat there.
Hold on. They say the Security Management Services Unit liaised directly with SSA for purposes of conducting.
Yes,
And the person who did that was Mr. Nshunzi.
yes.
Right, and he indicated that, let me go further down. So if we come to 8.3, at what Mr. Nshunzi indicated, right? Mr. Nshunzi, based on his evidence, is the person who goes and collects the security clearance certificates and returns it to the PP's office.
Yes,
And he would have collected the letter which is attached to your affidavit as well, correct?
yes,
And it's the contents of that letter that had gotten out into the public domain,
yes,
right? And subsequent to this report coming out, Mr. Nshunzi, hold on, let me just find the right page. Right, so if we go to your evidence, let me not skip over it, 8.4.6. Right. The investigators also interviewed you, correct?
I am now lost.
Sorry. I'm watching my time, and so let's go back.
Yeah, I can see you are
Go
driven by
up to
time.
8.4. I'm gonna
Yes,
do what my colleague advocate Mpofu does and just ignore the chairperson for a few minutes. In the course of this investigation, they interviewed you in your capacity as the chief executive officer.
yes,
And in the report, they relayed the information that you provided to them.
yes,
Right. And so I'm wanting to take you through what was said in 8.4.6 of that account of the account into what you indicated to them regarding your security clearance. And they recorded as follows: an applicant's manager is supposed to know the status of the results of the security clearance and communicate the results to the employee. Mr. Nshunzi is the only person who interacts with SSA.
yes,
Correct?
yes,
HR issues the Z204 forms of applications of security clearance, but is not involved in the security clearance. He does not believe that the senior management was involved in the leak, but does not discount that it may be someone at the junior level.
yes,
Right? Then in 8.4.64, you point out your view on the security clearance that's issued by SSA, and you point out in 8.4.6 that you'd received a call from SSA about your security clearance. So by the time you got the letter from SSA, you already knew that it had not been issued, correct?
I already knew that.
And you had discussed it with the public protector.
I already knew that it was not issued.
Issued,
Okay, yes,
right? And you had a discussion with the public protector relating to the outcome of your security clearance,
yes,
right? And you didn't know anybody in the organization that would know this information. And you then deal with some of the evidence that came to you. It was pursuant to this that certain recommendations was made in the report, correct?
yes,
Right. And in that recommendations at 15.11,
I think.
15, yes, Mr. You know it better than me. It was 15.11. Was it 15.11
Go
Alright.
under recommendations.
under recommendations?
Mm.
15.11.2,
Yes.
right? On the recommendation from page 1421. There were certain recommendations made by this organization that said on an operational level, the PPSA should also consider reviewing security policies and procedures to ensure it caters for all control weaknesses identified, and that in overhauling the security department to ensure that it meets the needs of the institution. To this end, they suggested that the CEO should appoint a properly qualified and experienced expert on organizational design to determine whether the personnel in that department have the necessary skills, qualifications, and capacity to occupy the positions they occupy, and to conduct awareness training on information management. Do you recall whether you had engaged that expert?
I wouldn't recall that we engaged the expert, but I know the 15.11.3 was done.
Okay, so in respect of 15.11.2, subsequent to this report, Mr. Nshunzi was moved from his position as
Security.
senior management security to customer services,
Yes.
right? And why was that done?
I just felt that with this report, we cannot keep him in that position. Rather, we take him to another position. And then I was advised that actually, looking at his CV and his skills, he will be best suited in that customer relations department. And then that was communicated to him, and then he was moved as such, and then we were to re-advertise the position of the security manager.
Right, so that position was then subsequently advertised, and there were applicants for that post.
Yes.
And just to round it off, if I go to page 1335, you were part of that interview panel,
Yes.
right? 1335 might be a separate different document. I think it's 61, right? In order to do those interviews, you have to fill out disclosure of personal knowledge and relationships with the applicants for the post during shortlisting, correct?
It's a standard procedure in all the interviews.
Right. And you would then, and you indicated in fact that you knew more than one
Applicants.
of the applicants,
Yes.
including the person who was, did you find it? That's 1335.
I know Mr. Jonathan Malachi and Mr. Amos Kosana. They are there in the declaration.
No, I think there was more. There was three. There was a, I can't read your handwriting, and that's why I wanted to put it on the screen. I'm sorry.
Just put it out.
Just indulge me. I've got two questions. Okay. It's only because I can't read your handwriting, and I want him to see that you made that disclosure up front
Yes.
in doing that.
Yes.
Right, so the PPSA has a standard disclosure of personal knowledge, and you put out that your relationship with shortlisted candidates is not of the risk that it's going to favor anybody. I'm related to or know what's that person at number 3?
But there's something wrong in this declaration form.
It says Vusi Lamini.
Yeah, it's it talks to Vusi Mahlangu, designation CEO. Look at the post, PR Eastern Cape. Oh, it was 2 interviews combined. Now
Two interviews combined.
Yeah, it was a provincial representative in the Eastern Cape and also senior manager security. Oh, no wonder there's more than one person.
That's why I thought I'll check the form because I wasn't. And there's more than one name in there. There's Vusi Lamini, and there's a second name.
It talks to Vusi Lamini, and then it talks to an internal candidate who's Jonathan Malachi, and an external candidate who's Mr. Amos Kosana.
And there was no impediment to you.
No,
And then if you go down to the bottom, I just want to take the comments. You identify Mr. Vusilamini. I'm sorry, Mr. Mahlangu, I can't read that. Can you just read it to us?
oh no, under comments, you now have to state the nature of your knowledge about the people that you have declared that you know them. Mr. Vusi Dlamini was the current acting PR in the Gauteng office. So he was already my colleague. And then Mr. Amos Kosana is from my previous employment, which is the Department of Rural Development and Land Reform. And Mr. Jonathan Malachi was, he was within the security unit as a security officer in the PPSA.
Right. Then my final question is, Mr. Mahlangu, you resigned, you tendered your resignation on the 23rd of December, 2019.
Yes.
Why did you resign?
It was a personal matter.
Sorry?
It was a personal matter, new opportunities.
And what position have you occupied since then?
I only occupy one position as a non-executive board member for Nkangala Economic Development Agency.
Right. And your termination was accepted by the PP, your resignation was accepted by the PP at that stage?
Yes.
Okay. Thank you for the indulgence, Chair. I got my tea time 12 minutes.
Thank you, Advocate Bauer. So it's 12 minutes past 12. I see you've been making that argument that you wanted to reclaim the 15 minutes tea time. That was granted. Thank you. We're now going to proceed, and I hope that Advocate Chabalala has his audio issues sorted out, because we're now going to proceed to cross-examination by the public protector legal team. Advocate Chabalala, can you talk to us? I can see you talking. IT, can we assist where the problem is? Is the problem with him or what's happening? He is talking, but we can't hear him. Okay, let me check others. Honorable Chantel King, can you talk to us? Chantel King, uitgevang. I proceed. Honorable Lechwase, can you talk to us? Honorable Lechwase, Titimalo.
I am here.
I didn't hear that. Can you talk to us? Okay. She's muted. Back to you, Advocate Chabalala. I seem to hear others on the platform except yourself. Can you please just sort that out? Because we do want to allow you to take the platform. Mr. Jafta, Honorable Jafta, welcome.
I'm here, Honorable Chair. Thanks very much.
Aye, Sabong. Thank you. We just a little bit of patience so that Advocate Chabalala can just sort out his gadgets so that we can hear him properly as he's going to be doing the cross-examination. Advocate Mayosi.
Chair, I've just had a WhatsApp communication from the PP's legal team.
They say if you could just give them an indulgence, they are switching computers to try and resolve the problem from their side.
Yeah, I saw he's taking the computer over the picture there. So we'll give them that indulgence. Hopefully it won't be too long. Are you winning, Advocate Chabalala? Are you back, Advocate Chabalala? We've just admitted you from another gadget. Just unmute.
Mr. Chair?
Yes, we can. You can hear you now.
Okay.
Switched off the video.
Mhm.
Okay, let me use that. Don't close it. I need to open the page for you.
The other one, the problem was the sound. In this one, the problem is the video. Advocate Chabalala's problems are multiplying.
You have not been recognized, Honorable Ngola. Sibhizi ngo-Advocate Chabalala. Awukabi ngo-advocate wena.
Yes. Mr. Chair.
Advocate Chabalala.
Yes, Mr. Chair, can you hear me now?
I can hear you, but I can't see you. Your audio is sorted. We can hear you now. God, I guess we look more on. The witness wants to see you, so that I go open and interact with you.
Yes, Mr. Chair. Can you hear me now?
I can hear and I can see you. Go ahead, Advocate Chabalala. The space is yours. Thank you.
Yes, Chair, once again, thanks for the indulgence, Mr. Chair. Seem to be sorted out now.
You certainly are. Were you loud and clear?
Yes, yes. Mr. Mahlangu, can you hear me?
Yes.
Yes, I understand that you were assisted by the evidence leaders to compile your affidavit.
Correct.
Yes. So the affidavit constitutes your evidence?
Yes.
Can I take you to?
Yes, I have the document. It's marked 2718, I guess.
Yes, yes.
Yeah.
Initially, you were reluctant to testify.
Yes.
Mr. Mahlangu.
Yes.
But you seem to have somersaulted now and changed your position.
I had to follow the proceedings, and then I just felt that it will be injustice for me not to present myself in person.
Initially, what was the reason why you were not keen to assist this?
The first few affidavits that I've read, I just felt that I can respond, I can provide written responses. But later I pick up that I may want to articulate some of the things and put them into context. something that is so difficult to do by writing only.
So if you say you were assisted by the evidence leaders to compile your affidavit, in what way did they assist you?
Basically, they interview, they ask questions, and then from your responses, they document the information that you provide to them.
So the document was drafted by the evidence leaders.
Yes, remember they interview and then they take a statement which they contextualize and then confirm with you if is this to your recollection what we have provided to them, and then yes.
But you can own up to this affidavit?
Yes.
The reason why I'm asking you is because we seem to have taken our eyes off the ball here. If I were to refer you, if I may refer you to page 2718, in fact, paragraph 3 of your affidavit. Can you see that? Do you have it in front of you?
Yes, I have the document, but which paragraph?
In front of, yes, paragraph 3.
2.
No,
Yes.
paragraph 3, the chair.
Mm-hmm.
Yes, I'm going to read out into the record quickly. You say, I was contacted by the evidence leaders and informed that there was a motion currently serving before Parliament, and that in respect of one of the complaints under the heading Chapter 4, I was named as a person who had intimidated, harassed, victimized a number of staff members whilst in the employ of the Public Protector South Africa. Can you see that?
Yes, I can see it.
Yes. What's your reading of this paragraph? Because in my view, my reading of this is that it only refers to, it doesn't apply to you because the impeachment process that is currently underway is in respect of the Public Protector.
Well, there were different versions because I was reading this and crafting this, but if you go to the complainant's affidavit, they refer to me as an enforcer. That I think it's somewhere in the document. So I'm also surprised why they are saying that to me, because I thought the entire hearing is about the Public Protector, but I couldn't stand and not be party to this if they are rubbishing my name like this. Sorry to use that language, Chair. So I felt that it is my responsibility to come before this committee and present my case against what they are saying about me. So you are right. It's supposed to be about the Public Protector, but one way or the other, I find my name all over the complainant's affidavits.
And your evidence is that you were assisted by the evidence leaders to compile this affidavit?
I will stick to that and say yes.
Yes, I'll tell you why I'm bringing that point again back, because I've gone through your affidavit. There's an important point that is missing in your affidavit, which falls within the knowledge of the evidence leaders. It could have been an oversight on their part, but it is relevant to this allegation in respect of Charge 4. I'm going to take the committee through. You remember that prior to the National Assembly this inquiry, in terms of the rules, there was an independent panel that compiled a report. Do you know about that?
When
which
I was approached
which
by
was
the,
chaired by Judge Basin Kabinde. Do you know about the independent panel's report?
I want to respond this way. When I was approached by the evidence leaders, they referred me to a number of documents within the parliamentary website. That's where I pick up the independent panel report. So I had an opportunity to go through it.
Did you refer to charge 4 of the report?
Well, let me give you a longer response. I called the evidence leaders and told them about my problem with the number of information that is there. It was more than 10,000 pages. And then we came to an agreement that I might as well focus specifically to those documents that are referring to myself. Then I narrowed my scope from my discussion with them. And then I went to exactly where my name was popping up.
You know why I'm not trying to take advantage of you, but it's because this charge is important to my client, charge 4.
Okay.
Because as much as you are implicated, but how it is phrased is that they seek to acquire or obtain evidence through you in order to prove this charge against my client. What do you say?
I don't believe that the evidence leaders came to me in order to corner me. I think we had an open discussion, and then for me to be here, I was driven by the desire also to clear my name. So in my reading of this charge, I don't think one way or the other I could be used to implicate the public protector, unless you explain further, Council, through you, Chair.
Yes, I will through Chair, that this charge, in terms of Judge Basin Kabinde, who chaired the independent panel, he found that there is no merit in this charge, and it was rejected outright. Can I flight the portion of the report that deals with this charge? I think it's important.
I think that will help, Chair.
Yes.
Yeah.
Can someone help me there? Go to flight bundle A, the independent panel report.
Yes, where exactly in the independent report?
Page 10481.
That would be a paragraph, eh?
Yes, that no, that
Was
will
it
be a page. That will be a page. 10481.
Of the independent panel.
Yes, paragraph 191, starting from paragraph 191.
191, okay.
Yes. Yes. Can someone flight it for us, please?
191.
Yes.
That's in her written response to this panel.
Yes.
Is that the paragraph?
No. These are the findings of the independent panel. Yes, in her written response to this panel.
In respect of the Baloy matter?
Yes. Let's go to 191.
There are 4 contentions there that the PP is making. Take us through.
Can you bear with me, Mr. Chair?
Okay. Are we able to fly to that? Okay. So I'm faster than you.
Mr. Chair, I'm not going to waste time going through the PP's contention. let me focus on the independent panel's finding, which is at 197. Which
Paragraph
comes
197.
considered the basis of the complaint as well as the people's response to the complaint. Judge, the panel of three, including Judge Basin Kabinde, they concluded that this is the charge that deals with the intimidation of the staff members on the part of Baloyi. It says, in the circumstances, we find that the Baloyi matter does not raise prima facie evidence of incompetence or misconduct.
Yes, I follow you.
Yes. My submission, Mr. Chair, is that this allegation has partly been dealt with by the independent panel, but my issue is not only that, because it can still maybe be alive. The issue that I'm raising is that it is not contained in Mr. Mahlangu's affidavit. That's my issue, the issue that I'm taking with this. That's the contention to say the affidavit is, they seem to have been selective when this affidavit was crafted. And in view of the fact that this evidence relating to Baloyi has been led today. What do you make of that, Mr. Mahlangu?
Okay, Chair, maybe let me just go back again to the documentation that was provided before me. Chair, to me, the main document was the independent panel report, and we discussed with the evidence leaders. Then in our discussion, I even made a comment to say, but it looks like some of these things have been dealt with. And then they said to me, no, it will be to your interest and advantage to go through all the documentation that are there, in particular where we are being mentioned. So in my responses, well, I responded to everything that I felt that touches to my name. Whether the matter has been concluded, if there's any blame, I don't know, I'll put to the evidence there to say, maybe they could have advised me to say, like we dealt with the Baloyi earlier, to say this matter is before the court. You may want to respond or not respond. I innocently respond to all the issues as they were presented to me.
Yes, Mr. Mahlangu, can I just bear with me? Can I take you through again to paragraph 192 of the same report by the independent panel?
Yes.
Can I read it out to you? I mean, to the chair and the committee. It says, although it is not for us to decide, there seem to be merit in the people's contention that the basis on which she is held responsible for the conduct of the CO, they're referring to you, Mr. Mahlangu, of the Public Protector Mahlangu, is not explained. Many, if not most, of the allegations are made against Mahlangu and not the PP.
Yeah.
You remember my earlier submission that charge 4 has got nothing to do with you.
Chair, I think I will ask your guidance in this case because, well, mine was to cooperate with the evidence leaders. And I think I've done that. I provided that. I given every information they want. I answered every question that they want. We even agree on the evidence that I provided. So I wouldn't want to argue with the advocate, Shabalala.
Mr. Mahlangu, I'm not trying to criticize you.
Yes,
The point I'm making.
Sorry, pause, Advocate Chabalala. There's just a request that perhaps you reposition yourself and be much closer to the mic so that we can hear you properly.
Chair, can I just correct something? I wanted to say.
In the meantime, yes, do.
Yes, I don't want to dispute what he's saying, but maybe you can give us the guidance of how we proceed if the evidence leaders made me to respond on issues that have already been dealt with.
All right. Well, let's go through it. Let's see how. Advocate Chabalala.
Yes, Mr.
Go ahead.
Matangu, I'm not.
Now you can hear
I'm
much
not
better.
I'm not trying to criticize you. The only point I'm making is that your affidavit is incomplete and trying to highlight the shortcomings in your affidavit. That's the only point that I'm trying to make here. I'm not trying to criticize you.
That's very clear. Go ahead, Mr. Matlango.
Chair, in order to not to delay the committee or to dispute what the advocate Shabala is saying, I will concede. But I'll also make a disclaimer that I followed the guidance of the evidence leaders in my responses.
Thank you, Mr. Matlango. Mr. Matlango, still on this point, because you seem to be exonerated or the PP exonerated only insofar as Baloyi is concerned. I would like to deal with the legislative framework which defines the functions for the public protector as well as those for the accounting officer. Yes, Mr. Matlang. Are you still with
Yes,
me?
I'm with you. Yes.
The act. Where is the act? Yes, Mr. Chair, I would like to, Honorable Chair, I would like to
Even
refer.
chair is fine. You go ahead.
Okay.
I'm chair or chairperson, no problem.
Thanks. I don't want to be accused of disrespecting this House committee, Mr. Chair. Can I refer this committee to, Mr. Chair, can I refer you to Bundle C, page 37?
Repeat that page on the bundle.
Bundle C, page 37.
Did you get that?
Yes.
Okay.
Yes.
Can you flight it, Tsepo? Advocate Mayesi?
Sorry, can they specify which item in bundle
Yes.
C?
Yes, Mr. Malo, can you bear with me? Be patient, Ms. Bayusi. I'm coming to that, please.
No problem.
We're dealing with, can she exercise a bit of.
Go ahead.
Yes.
Sure.
I was waiting for the document to be flighted, but I can take the House through in the meantime.
In order to find it and flight it, we have to know what item number it is in bundle C.
Yes, I was getting to that, Mayosi. Then you interrupted me. Please, can you bear with me, please? Mr. Chair, I'm referring to section 182.
182
of the Constitution. That's to find in your bundle C on page 37. It refers to section 182 of the Constitution. Here, the heading, it deals with the functions of the public protector. I'm not going to go through the whole section, but I want to highlight the core functions of the public protector. I'm doing this exercise in the context of demonstrating that Mr. Mahlangu, since he was employed as a CEO, he could not have performed the functions of the public protector. Vice versa, the public protector could not have performed the functions of the CEO as they are precluded in terms of the Act. As we may know that the public service can only perform the functions that they are empowered so to perform in terms of any of the legal instruments, which could be either your constitution, your subsidiary legislation, or the statute. According to this, in terms of this section, there are three core functions of the public protector. One is to investigate any conduct in the state affairs. Two is to report on that conduct. Can you hear me, Mr. Chair?
Yes, I follow you. You are now on subsection B.
Yes,
Section B, yes.
Now I'm on subsection C, to take
Yes.
appropriate remedial action. These are the core functions of the public protector. On the other hand, I would like to refer this House, even if maybe for the sake of time, this document is not flighted, I can quickly read it out into the record, but it's found in bundle C, page 66. This is the Public Protector Act. Yes, the Public Protector Act. Bundle C, page 66.
Bundle C, page 66.
Yes.
It will take us to the Public Protector Act, which is the legislation.
Which is the legislation, yes.
Thank you.
There, I would like to refer you, Mr. Chair, to page, section 3 of the Act. In particular, 3(1)B, which states that the public protector shall, subject to his or her discretions and control in the performance of his or her functions under this Act and the Constitution, be assisted by A, the public protector, B, a suitably qualified and experienced person as chief administrative officer appointed by the public protector or seconded in terms of subsection 12 for the purpose of assisting the public protector in the performance of all financial, administrative, and clerical functions pertaining to the office of the public protector. Mr. Mahlangu.
Yes, sir.
Are you familiar with these legal instruments?
Yes.
As appears, you, in your capacity as a chief executive, you were located under this section, section 1B. Are you familiar with this?
Yes.
So you could only perform these functions that are stated here. Yes.
Yes.
And the disciplinary processes or proceedings, would I be wrong if I submit that they follow under your authority in terms of the Act?
No, you're not wrong. You're right.
Yes. And the public protector's functions is only limited to the three core functions that I've referred you to.
Yes.
So she must stay in her lane and you stay in your lane all the time.
Yes. But the wet lane.
And unless there's a coalition.
The wet lane.
Yes, Mr. Chair, I understand, but I'm not there yet.
Okay, go ahead.
Yes, yes. I just want to demonstrate that the powers are clearly defined here. Mr. Mahlangu.
Yes, sir.
If you don't mind, can you being the chief executive officer, do you also become an accounting officer?
Yes.
And the public protector is what, an executive authority?
Executive authority.
Yes.
Yes.
And then under your structure, can you quickly take us through
the
the
organogram?
organogram? Yes, please.
It will be myself, the accounting officer in the act is called the chief administrative officer, which is the CEO. Then immediately, if you discount your immediate staff like the PA, you get a straight line that goes to the COO, and then another straight line that goes to the chief financial officer. And then I think, yeah, even the legal services, the straight line to the chief administrative officer. That's it, Chief.
Tell me the HR in this structure, where does it fall?
The what?
The HR, human resource.
Okay, let me just confine myself to PPSA. Yes, we are right. A reminder, the legal services, the HR, CFO, also the COO had a direct line to the chief administrative officer, which is the accounting officer. Unlike in other organizations where you find that the HR and legal services report to the COO, then who reports then to the CEO. Because it's a small organization, the HR and legal services also reported directly to the CEO.
As the executive authority, the public protector does not get involved in the administrative issues.
Yes.
So all the disciplinary processes were obviously initiated by you or in your instructions?
By me or instructing the HR head to execute.
And your evidence is that, and in fact, even in terms of the act, the public protector does not get involved.
Yes. I think we have explained the legislative functions and the act itself about the public protector, so you are right.
It would in fact be unlawful if the public protector were to get involved in the administrative fund. Yes.
Yeah.
So I don't want to waste your time, Mr. Mahlangu. I just want us to go back to your affidavit. I just want to take you back because I've been able to establish the legislative framework. And let's first deal with Mr. Samuel. Mr. Mahlangu?
Yes, I'm with you. Which
Yes.
paragraph on my
Yes, can you go
affidavit?
to, yes, can you go to paragraph 23.5? You say
20, sorry, 20?
23.5.
The one being flighted now.
The one being flighted now.
Yeah, okay.
You say you do not recall having directly dealt with someone. In that, given the hierarchy in the office, it would have been dealt with by the then acting CEO. What do you mean?
Yes.
Yes. What do you mean?
I think the question there was, how did the matter arose of Mr. Samuels? And then I explained earlier that the legal services brought the matter to my attention. And then I referred the matter to the HR so that I can be brought to speed about the history of this assault case. So because of the time, the sequence of events is the one that I necessarily do not recall having dealt with him directly, because one of the things was that since Mr. Samuel actually even currently is at the provincial office in the Free State, he may be reporting to the whoever at that time was the provincial coordinator, which could be Stoffel, Mr. Forris, Advocate Forris, sorry, or the then COO, Mrs. Ntoriseng, before Mrs. Balo was appointed. So it's a question of when exactly, when this thing happened exactly, who was the in charge there, whether it was Ms. Baloi or Fori or Ms. Mutsitsi. But we discussed at length with the evidence leaders. I thought they could have by now clarified who was in charge at that time, and the one who had direct supervision to Mr. Samuel to present.
Yes, but Mr. Mahlangu, the main issue here, which I think you have clarified, which I think you can still remember very well, is that this Mr. Samuel issue emanated from the legal services. We have in our possession here a letter from Mr. Nemasisi addressed to the public protector on this issue and the CEO. In fact, we have shared it with the evidence leaders, and we have requested for this document to be uploaded. As soon as it is uploaded, I'll be in a position to share it with the committee. But yes, you are right. It emanated from the legal services. Oh, here it is. Yes. It's flighted already. Can you see that?
Yeah, but okay.
The
Yeah, I
sound
can
to
see
be
it,
heard.
Chair. So
Reservations.
no, if I was provided with this, obviously I was going to amend my affidavit.
Yeah.
So
I'm trying to assist you, Mr. Mahlangu. Yeah.
Yeah, no, it's fine. I can see the document.
Yeah. Are you grateful that I'm trying to assist you?
Advocate Chabala is looking for commission later. You will be granted commission later by Mr. Mahlangu.
Okay. And then can we move on? Okay, with your permission, Mr. Chair, can I quickly go to paragraph 2 of the email, which reads as follows. Any person convicted of crime may be a risk to the organization especially when the offense took place at our premises and during office hours. My advice is that disciplinary action must be taken against an employee for bringing the organization into disrepute, amongst others. If no action is taken against him, it will send a wrong message to the employee. You say this, Mr. Mahlangu, it doesn't come from you. It doesn't come from the public protector. This is an independent advice coming from the legal services. So anyone who accuses you of having been an enforcer for the public protector, on the basis of this, you can be in a position to challenge that person and maybe call him or her a liar.
Yeah, correct.
Do you accept this, my proposition?
I accept.
Yes, thank you.
But not necessarily to call people names.
Yes. Mr. Mahlangu, can we quickly now deal with Mr. Neshunzi?
Okay.
You see, on page 2725, that's paragraph 24 of your affidavit.
Okay.
Were you involved? Did you take any part in the disciplinary proceedings of Mr. Neshunzi?
Mr. Nechunzi was never disciplined. It was an investigation. Yes, it was an investigation which I didn't take part, but I was also interviewed by the investigators. Is it still there, Chair?
So you come again, if you can repeat yourself there, Mr. I'm sorry, I was just concentrating on something else.
I was clarifying the kind of words that you used about Mr. Nechunzi, that did I take part in his disciplinary? I said he was not disciplined, but there was an investigation that took place, which was conducted by HR in conjunction with legal services.
So you were not directly involved?
No, I was not directly involved. I was also one of the people.
Neither was the public protector was directly involved. Yes. Thank you. Mr. Chair, I don't know, it's lunchtime, whether I can proceed to the next topic.
Advocate Chabala, no, thank you. I can see both yourself and Advocate Bauer. You're very conscious of time today. You're helping the chair. We will pause there, Advocate Chabala, and break for lunch between now and 2 and come back, and then you'll continue with your cross-examination. So thank you for being kind to allow us to go for lunch. We pause, colleagues, and we'll come back at 2. Thank you.
Thank you.
Recording stopped.